Yep. There's no mic saying that. We have just filed a petition requesting that a judge order Mr. Bill Watson, who is the coroner, to conduct a coroner's inquest. The petition essentially says that Mr. Watson has a duty to conduct an inquest whenever there is an unsettled issue regarding the cause and manner of death. In this instance, we believe that based upon the two autopsy reports which conflict with one another, that he has a duty to convene a hearing whereby jurors can decide whether Kendrick Johnson died as a result of an accident or whether it was a result of a homicide.
A coroner's inquest is an inquiry into the cause and manner of death of an individual that is conducted by a coroner, a court reporter, and 6 jurors from the county where the death occurred. We think this is critical in this matter because of the totality of the circumstances, that the official manner of death has now been concluded by the coroner. When you think about the missing clothes, the missing organs, the second autopsy, the fact that there's a video surveillance that will show what happened to Kendrick Johnson, and the fact that this coroner has to consider witness testimony, video surveillance, in light of all the other things that are questionable about this investigation, to make not only the public have confidence in this finding, but this family to have some peace of knowing what really killed their child. That's all Attorney King filed today. We were very technical in trying to get to the crux of the matter so this family can have some peace in knowing what happened to their child. And if that video shows others in that gymnasium, as has been reported, then they have a right to have this coroner's inquest. It is right and justice demands so. At this time, Attorney King and I will try to answer a few questions about our strategy going forward and how we think this is going to be timely resolved, is our belief.
How long will it take to get a decision, and what is your strategy going forward?
Well, I will talk about the timetable, and I will defer to the co-counsel, Attorney King, who's been doing all the filings in this matter, to talk a little more about strategy. The timing is set for October 30th to at least have a hearing to answer this question about the video surveillance coming forward. It has been told to this family that the video surveillance in the high school gymnasium is an academic record. Now, you know, when you think just common sense, let's not even talk about the law for a second. Common sense would suggest that a video surveillance tape is not an academic record. It is there for people to be able to look at the contents of it to decide if something happened. So Attorney King and I will present on behalf of this family reasons why this videotape should be released. And then you have a follow-up before we talk about it.
Well, yes, but I guess I need to answer to my first question. But the second question I have is the school district told me that it's a privacy issue, which is the reason why they can't give you the video, and that attorneys knew that, and all they have to do was file a motion to get the video.
Now, you know, and Attorney King can address this. In this age of technology, all this technology here in this courtroom, how easy would it be to gray out the faces of the others and release that video versus trying to put up road barriers to the truth?
Would you like to respond?
Well, with regards to the comment that the school board attorney made, saying that all we had to do was to file a motion, that's not exactly correct. The petition, the lawsuit itself, was the request. It was the motion. They had an opportunity to respond, either to consent to our request, that they give us the video, plus unredacted copies of the investigative report, or that they fight it in the name of maintaining privacy that they claim these students are entitled to. Now, it only stands to reason that for as many times as you and the media report altercations on school buses that are covered by video cameras, and you have no such problem making that information public, how could these parents be denied the opportunity to see a similar kind of transaction and it somehow raise a privacy issue?
The technicality, you know, the technicality, all they had to do was file a petition or request. When you really think about from day one, these parents and Attorney King have been asking for the video surveillance to be released. And now, at 10 months past the say, oh, all you have to do is file a request, we will give it to you. Would we be here filing these legal actions if it was that simple that they were going to give this videotape up? We absolutely believe somebody has already viewed that videotape, and for whatever reason, they do not want these parents to view that videotape.
Now, is it true that right now that video is in the hands of the U.S. Attorney's Office, Michael Moore in particular?
We think the video is in the hands of a lot of government officials.
Getting back to the first question that I had, tell me about the timetable that you expect to hear something back from this motion that you just filed.
Well, as I said, this is a petition for writ of mandamus. Essentially what that is an order directing a public official to do what they, by law, have a responsibility to do. And in this instance, the hearing on this petition must take place in no fewer than 8 days and no more than 30. So at some point between those two markers, the judge will, based upon his availability, set down a date and time at which Mr. Watson will then be expected to appear and to respond to that petition.